Ok, possiamo cominciare. Prima di iniziare vorrei ringraziare gli organizzatori, in particolare il professor Nesi, il professor Perti e il professor Ali per avermi invitato, in particolare a presiedere questo panel con colleghi da diverse aree del mondo, dagli Stati Uniti all'Inghilterra. Il panel I will switch now to English, and this panel on the condition of migrants and refugees will explore the condition of migrants through different theoretical lens and different perspectives. I think we can wait for people coming. In so doing, the speakers will critically discuss the positive but also the negative implication of a more protection-oriented approach and development to migrants and to migration and refugee law. So without any further ado, I will give the floor to Professor Ralph Wild from UCL, University of London, that will discuss whether a progressive development of refugee law, in particular in the context of extraterritorial applicability of human rights and the extraterritorial application of the principle of non-refoulement, might have unintended consequences and does undermine refugee protection in other areas. So Ralph, the floor is yours. If you want to, you can use PowerPoint.
Here or
As you prefer.
I'll stay here. Thank you very much. It's a great pleasure and honour to be here. Thank you very much to the organisers for including me on the programme and also giving me this chance to speak to you and to such a distinguished audience of experts in this field. Now, of course, one story that can be told about the development of legal protections for refugees in international law is, in terms of the scope of protection, a progressive one. For example, in the acceptance of a non-refoulement type obligation, obviously an obligation not to send people back to face certain forms of human rights abuse, and acceptance of this not only in refugee law but also, of course, in human rights law. Yet a corresponding opposite story can be told, a diminution on the part of many, particularly economically advantaged states' commitment to refugee protection, as evidenced in the expanded scope of non-entree measures, from visa restrictions to carrier sanctions, pushback operations, and an unwillingness to engage in numerically significant refugee resettlements to their countries. How can and should the causal relationship, if any, between these two chronologically overlapping, normatively divergent developments be understood? In particular, have progressive developments played somehow a causal role in the broader trend of resistance to the protection of forced migrants in general, refugees in particular? And moreover, given the actuality of this resistance, what is at stake when legal developments continue to push in a progressive development? I'd like to explore these questions through the case study of progressive legal developments in the application of the human rights law obligation of non-refoulement in the extraterritorial arena. That's to say, in relation to states' actions outside their borders. And my remarks on this topic form part of a broader research project called Human Rights Beyond Borders, which is a critical interdisciplinary evaluation of the topic of the extraterritorial application of human rights law, funded by the European Research Council, which is, of course, the academic funding body of the European Union. Thank you, European Research Council, and indeed European Union. The Application of the non-refoulement obligation extraterritorially, of course, combines two of the main progressive developments in the field of human rights obligations generally: non-refoulement and extraterritorial applicability. This comes on the heels of the former obligations at non-refoulement being accepted and the scope of their coverage expanding in the territorial context, and the latter obligations, extraterritorial applicability, also developing in a somewhat similar fashion in more recent years. Now, in a synthesis of both developments, marking a further development in each, there is an acceptance that the non-refoulement obligation in human rights law applies in certain extraterritorial situations, as affirmed in, of course, the Hersey decision of the European Court of Human Rights about Italian maritime pushback operations. Now, within the general context of extraterritorial action, I'm going to focus on activities aimed at migration control, the extraterritorial operation of border checks, interception, and pushback at sea, etc. Symbolized here, forgive please the parochial reference, the extraterritorial posting of border officials from France and Belgium at the St. Pancras Eurostar terminal in London, not far, temptingly close to my office, my university at UCL, literally 5 minutes walk. Now, the progressive developments in the extraterritorial application of human rights law have the effect of grafting onto these activities somewhat similar core protections for individuals as would apply to equivalent activities taking place territorially. Of course, this falls short of equivalent protection, given the limited circumstances in which human rights law applies extraterritorially and important practical impediments in the field of enforcement and third-party scrutiny. But nonetheless, in certain key respects, it's a radical shift, introducing constraints on the state compared to the situation before these standards were applicable. On the issue then of non-refoulement, this means that, as in the Hersey case, states can no longer lawfully engage in refoulement extraterritorially, which would be unlawful, at least as a matter of human rights law, territorially. What has to be reckoned with here is the extent to which this development constitutes a direct challenge to the very reason for some of these extraterritorial activities in the first place. The way the action is essentially an extraterritorial manifestation of an activity that would normally take place at or within the state's borders. So, for example, pushback being the extraterritorial equivalent to deporting migrants once they've reached the state. This requires us to consider why the extraterritorial locus has been chosen and what the implications such a choice has for the question of protective legal regulation. Account has to be given here, and again forgive the parochial references in the images to issues in the UK, to the increased resistance on the part of many economically advantaged states towards inward migration in general, and the migration of individuals protected from refoulement in refugee and human rights law in particular, the non-entree policies I mentioned earlier. Extraterritorial migration-related activities have to be considered then, not only in a neutral way, capable of implementing policy that could potentially be relatively receptive or restrictive of migration. Rather, this broader context requires us to consider how these activities might be viewed as a means of furthering non-entree policy in particular. In consequence, it's necessary to ask whether the objective of circumventing legal restrictions that would operate were these activities to take place territorially might indeed lie behind the move offshore. If this is the case, the question arises, will the legal move of following state activity to the extraterritorial arena precipitate a counter-response by states? And what might that response look like? And should this matter when considering the merits of the legal move? What negative blowback consequences for protection might be precipitated by the progressive legal developments that have taken place and might take place in the future? So what might happen? Well, in the first place are responses that might be understood as still ultimately accepting the assumptions of the normative regime, but which involve more extreme restrictive measures taken against individuals as before. An example of this would be the policy device of forcibly transferring migrants on their way to, or having arrived at, the state's borders to a third location, allied to the claim that the refugees affected will not suffer as far as the non-refoulement obligation is concerned, because the third location is deemed safe. This approach, the spirit of which of course being captured in the EU law Dublin first country of asylum regime, can be seen in the Australian policy of intercepting migrants at sea and transferring them to extraterritorial centres such as in Nauru and now Papua New Guinea. It's of course also been discussed in Europe for some time and has resurfaced here recently during the recent so-called crisis, with the possibility of creating such centres somewhere in North Africa being discussed. Approaches such as these can be seen as responses by states which, on the one hand, gesture to an acceptance of the position that if migrants fall within their control, whether territorially or extraterritorially, they do bear an obligation of non-refoulement, but, on the other hand, seek to avoid the usual consequence of this, which is that they discharge their obligation through hosting the individuals entitled to protection within their own territories. The consequent reduction in the numbers hosted is seen as a benefit not only in and of itself, as far as the individuals directly affected by it are concerned, but also because it's regarded as acting as a deterrent to others in the future who might try to travel to the states concerned, not just to obtain protection in general, but to obtain protection that would be delivered in those states' territories in particular. For the individuals directly affected, therefore, the arrangement isn't on its own terms supposed to diminish the protection required by the non-refoulement obligation. They are still supposedly going to be given this protection. But in shifting the locus where the protection will be realized to an extraterritorial location, it worsens the unequal distribution of refugees globally. That this can be done while attempting to stay within the boundaries of the non-refoulement obligation indicates the limited nature of international law in this area, which, as we know, doesn't provide for a binding regime of equitable refugee hosting between states. In this respect, then, the backlash precipitated by the progressive development, if this is indeed what it is, doesn't necessarily lead to a diminution in the protection provided by the law, but has come at the cost of worsening a separate problem, not covered by the law in terms of binding obligations, in the area of the equitable hosting of refugees between states. For individuals affected in a broader way, whereby the exemplary nature of this arrangement deters them from attempting to travel to the states involved in the first place, the arrangements might have a similar effect if the individuals are able to obtain protection elsewhere. But if they're not so able, if travel to the states implementing these measures is the only route to protection, then the danger is that protection itself will not be realized. Thus, the arrangements would lead to a diminution in protection. Here, then, the backlash response will be effective in reversing the practical significance of the progressive development. The non-refoulement obligation might apply extraterritorially, but people have been deterred from travelling into the zone where they would benefit from it. since the deterrent effect is based on shifting the place where protection will be afforded to a less desirable location, the effect of the backlash response illustrates how the international legal regime only offers core protection, not also addressing broader issues of equitable hosting or, to much extent, the material conditions in the site of protection. States can respond to the progressive developments by exploiting the lack of effective regimes dealing with these broader issues, to generate disincentives that diminish protection and thereby undermine the practical effect of the progressive developments. Account also needs to be given to how progressive developments that would lead to greater numbers being given protection precipitate broader backlash measures in other areas which, although not undermining developments as such, aim to reduce numbers overall. Carrier sanctions and visa restrictions could be tightened up. Even more efforts could be given to the policy of containing forced migrants in refugee camps in developing countries, symbolized here by an aerial picture of the Dadaab camps in northern Kenya, where I did some work 20 years ago and are still, of course, in existence, although under threat in terms of the policy of Kenya. This policy of containment, of course, engineered by developed states through leverage exercised financially and in other means in relation to UNHCR and host states. In consequence, fewer people would be able to enter zones of protection, or at least these zones where the material conditions are better than in the initial locations of safety. These measures might have the effect of reducing and possibly cancelling out the effect of the progressive developments in expanding the numbers of people protected. Indeed, it might even lead to an even lower number of such people than was the case before the progressive developments occurred. This possibility that the backlash responses to the progressive developments may be of such an extreme measure that they lead to a position even worse than a situation without the progressive developments would be obviously the consequence of a withdrawal from human rights instruments, as has been discussed, again please forgive the parochial reference, in my country, the United Kingdom, where for this moment, I haven't checked the situation in the past 10 minutes, the Prime Minister personally wants to pull out of the European Convention on Human Rights and revise the Domestic Human Rights Act, obviously and partly for reasons directly related to the non-refoulement aspects of these legal regimes. In fact, that really is the main issue as far as she's concerned. Obviously, these actions, if implemented, would drastically diminish legal protections territorially as well as extraterritorially, and in relation to all rights, not just the rights of migrants. Now, I should be clear, I'm neither asserting a clear causal link between progressive developments and backlash responses, nor predicting what will happen in the future. Rather, I'm speculating about what might be happening and what might happen in the future based on the factual coincidence between the two phenomena. Ultimately, the clear evidence that many economically advantaged states wish to adopt non-entree measures in the context of widespread popular xenophobia indicates that the stakes are particularly high when legal developments cut against this. I'm not suggesting necessarily that the progressive legal developments are mistaken, nor that efforts to further and deepen them are misguided. Rather, I'd like to suggest that it's important to acknowledge that improvements in particular areas need to be assessed in a broader context. At the very least, the notion of progress itself needs to be approached holistically, and consideration needs to be given to how the combination of improvements in particular legal areas with serious regressions elsewhere might leave things overall no better or even worse. Thank you.
Thank you very much, Ralph, for this presentation and for raising very provocative questions that I think we might address better in the Q&A session afterward. I now give the floor to Francesca Ippolito, associate professor at University of Cagliari. Francesca will discuss the issue of vulnerability and in particular in judicial reasoning of international court. And she will ask whether a concept, a normative criterion is emerging for the development of refugee and migrants' rights.
So thank you, Maria Giulia, and thanks to the organizer for including me in this panel, giving the opportunity to speak to you and present this question. So the aim of the presentation is to draw the attention on a social and ethical concept that is gaining a momentum in the legal reasoning of all international human rights bodies during migrants' adjudications. That is vulnerability. Vulnerability is a composite notion which combines a universal dimension as embodied beings. We are all vulnerable, but also a particular dimension. We experience the exposure to harm uniquely, depending on our degree of resilience and dependence and autonomy. But it is also a relational concept. It is the main important dimension for the judicial reasoning because it suggests a relationship of responsibility between the state and the individual. So the attention on the concept is worthy insofar as vulnerability analysis in migrant adjudication at international level paves the way for a welcome improvement to present-day human rights interpretation under the traditional liberal matrix. It sophisticates the human rights interpretation, enabling a context-sensitive and a nuanced assessment of human rights violations, and ethically strengthens the argument of justice, shedding light on better delineating the scope of state duties. So the presentation will be divided in two parts. The first one will assess the descriptive dimension of the concept, and the second one its perceptive dimension. So starting from the first one, the descriptive dimension of the context of the concept reflects the composite nature of the notion. And we have the baseline of a collective dimension that reflects the universal dimension of the concept that appears in the judicial reasoning through the notion of vulnerable groups. And then this concept has been framed in a more individualized way to give count of the particular dimension of the concept. In which way? So, for instance, asylum seekers, as many of you know, has been qualified as vulnerable groups by the European Court of Human Rights in the leading case MSS, stemming their vulnerability by their complete dependence on the states in the fulfillment of their basic needs and because of their traumatic experiences in the journey. And all asylum seekers have been qualified as a vulnerable group. But then the same European Court of Human Rights has progressively nuanced the concept and framed it in a more individualized way in two ways. So the first one is through the notion of compounded vulnerability. So through a reasoning on the superposition of multi-factors to the one of being seeking international protection. So for instance, being seeking international protection and being at the same time a child or a woman or a person belonging to a sexual minority, and considering these multi-factors separately. This serves to reinforce asylum seekers' procedural and substantial rights, in particular limiting the state's arbitrariness and requiring the application of a more stringent necessity test when it comes to the deprivation of liberty, but also in the context of expulsion in some way. so with the different notion of proofs of vulnerability in the two contexts, which is clearly different. Then we had a case in 2017, Ilyas and Ahmed, in March, that gave a completely different way of individualizing the notion of vulnerable groups. And in this case, the shift toward a more ad hoc based approach has the effect of granting states oppositely a considerable room to decide case by case who is entitled to a wider degree of protection by virtue of their heightened vulnerability, because the court said that the applicants were not more vulnerable than any other asylum seekers detained at that time, stressing the fact that the circumstances that the events in Bangladesh, which gave rise to the applicants' flights, had happened several years before their arrival in Hungary. And so it's a completely different approach. A sort of similar negative effect of individualizing the vulnerable groups, so the collective notion of vulnerability, we find in the European legal order. And so in all EU asylum acquis, where the European Union adopted a selective notion of vulnerability. So not all asylum seekers are vulnerable, but only those who are unaccompanied minors, who are pregnant women, who are belonging to sexual minorities, and so on. And in all the different instruments of the EU asylum acquis, the categories are different, so are not the same. And in the Return Directive, as to irregular migrants, we find again a selective notion that is an exclusive one, so not an open-ended notion. The category of irregular migrants have been qualified in a selective way also by the European Court of Human Rights, where its jurisprudence has not embraced a vulnerability conceptualization because of the deprivation of a status per se, as to the adequateness to effect the gravity test of inhumane and degrading treatment, ex Article 3, or in cases concerning Article 8. So in these cases, the vulnerability of irregular migrants should be combined with a fragile health state condition and the condition in the host states. A partial reversal of the position or a mitigation of this position of the European Court of Human Rights we find in Chowdhury and others versus Greece, that is the case of 2017 concerning 42 Bangladeshi migrants, workers recruited to work in the strawberry fields in Manolada, where the European Court of Human Rights insists on the vulnerability caused by a precarious administrative situation that increases the risk of labor exploitation. And in this context, the European Court of Human Rights placed itself more in line with the jurisprudence of the inter-American system and with the jurisprudence of the Human Rights Committee that considered undocumented migrants in two cases of 2017 often face a double victimization, given that on the one hand, irregular status placed them at the higher risk of violations of their human rights, and on the other hand, their human rights access to justice is also undermined by the fear of deportation. So the last way of individualizing the notion of vulnerable groups we find in the inter-American system, and is the recourse to the different notion of situational vulnerability. So a vulnerability that is considered in a specific context. And so it's the context that give rise to the vulnerability more than personal factors. And this we find in, since the advisory opinion number 18 on undocumented migrants, but also in the advisory opinion 21 as to migrants' children, and Velez Law versus Panama, and also for asylum seekers in Pacheco Tineo. Interestingly, also the International Court of Justice seems to approach the notion of vulnerability. It approached this concept in relation to provisional measures, and the International Court of Justice made it clear in Georgia versus Russia's Federation, because of segment of population are found in vulnerable situation because armed conflicts, but also because they remain internally displaced or are refugees. And Cansado Trinidad proposed in the last case of last month to substitute and use the vulnerability test to substitute the current plausibility tests for provisional measures, thought it was only his dissenting opinion, but it may pave the way for new pathways also before the International Court of Justice. Or the argument of vulnerability that sends an alert about persons or groups of persons that require that another entity, the states, do something to help them exert their state or vulnerability and to prosecute and repair their situation, trying to avoid stigmatization, which is the main risk of using this concept. So a convergence of an ethics of vulnerability and an ethics of needs introduce the perceptive dimension of the concept, and so the second part of this presentation, making vulnerability an instrument of functional protection, possibly for migrants, because it imposes correlated special state duties. So in which way is framed this specialty of duties for states, which correspond to special rights for migrants? I try to cluster them in 4 points. So one way in which we find this specialty is procedural derogatory regimes. And this is the case mainly for children. This happens in the European Union for the Dublin regulation in the MA case, where the special aggravated vulnerability of unaccompanied minors imposed the need to do not extend more than strictly necessary the procedure for determining the member state responsible to examine the application lodge, but happened also more broadly in MADI, where for the return directive, the Court of Justice introduced the possibility for states to authorize migrants who should be returned according to the return directive to stay, particular for compassionate and humanitarian reasons, so implicitly introducing a vulnerability conceptualization as guiding criterion for orientating national discretion as to the derogatory regime protection. Then vulnerability also endows states positive obligation to prevent violation with a certain minimum content, and we find this in the jurisprudence of the European Court of Human Rights, mainly as to children, for instance, in the context of administrative detention, and the case Mubilanzila is illustrative at that regard, but also for victims of trafficking, and then we have the case O'Keefe versus Ireland that also illustrates that how states are required to provide adequate protection for children and other vulnerable groups, so not only for age vulnerability, and should include reasonable steps to prevent ill treatment of which the authorities had or ought to have had knowledge. But vulnerability also interestingly impacts on the proportionality assessment. Proportionality assessment, whereas to the detention, so again is the case of the European Court of Human Rights, Mubilanzila again, and also this other saga of detention, because the length of detention cannot be excessive per se, but it could be perceived, for instance, by a child as never-ending, bearing in mind that facilities are ill-suited for his or her accommodation and age. But also, vulnerability impacts as to the national due diligence applied to a Dublin transfer, where the European Court of Human Rights and UN monitoring bodies derived from a vulnerability conceptualization and intermediate category, where Dublin returns can take place, but only after special guarantees are obtained. What clearly impact on the proportionality evaluation of the member states' discretion in the recourse to the discretionary clause under the Dublin system. And in the case of the European Court of Human Rights, this vulnerability is anchored to personal factors. So if we think to Tarakel, it was the case of age vulnerability and the family unit that were concerned, and where slightly different in the case of the Human Rights Committee, vulnerability should also include indication of the past experience of the removed individuals in the country of the first asylum, so quite recurring to a situational vulnerability concept and not only a personal one. And then we have the case CK before the Court of Justice of the European Union, where the dimension of systemic deficiencies representing the exceptional circumstances able to rebut the presumption of equal protection by all member states of fundamental rights, have been interpreted in the sense that not only deficiencies of national asylum procedure and reception conditions, but also encompassing those deficiencies that the court says affect the health care and sustains of particularly vulnerable persons, such as a mother and a child. And so these personal factors became an aggravating circumstance able to lower the threshold to triggering the protection afforded by Article 4 of the Charter of Fundamental Rights, but also an element of appreciation of the severity of treatment being determinant in moving the cursor between inhuman and degraded treatment or torture. And lastly, vulnerability plays a role on reparation. And this is clearly demonstrated by recent cases of the European Court of Human Rights, where the court recognized measures of just satisfaction for material and moral loss for irregular migrants exploited. And that is differently, before the Inter-American Court, the division of irregular migrants in terms of vulnerable groups being at the origin of the diversified range of reparation benefiting the whole group of existing and future irregular migrants, such as the obligation to organize and run specific training for civil servants working with immigrants. And this leads to the final consideration that in such situations where international jurisdiction are the last hope for migrants, and the same institutions from which is awaited a protection based on vulnerability rationale are themselves in a vulnerable positions, because I thought to the ineffectiveness in terms of enforcement of judicial decision of the most advanced system of protection, which is the Inter-American one, compared to the European one. Because unlike the European system, in which the Committee of Ministers, so we have a political control on the enforcement of the judicial decision, in the Inter-American system, it is a judicial system. So it is the court itself that has to be able to enforce or to control the enforcement of its judgment. But this could be challenging insofar as the Inter-American Court has a very limited budget and cannot afford to have an extended team of attorneys to help with the analysis of the country reports. So concluding, if vulnerability has positively emerged as underpinning for human rights theory and contributes to shed an ethical light on interpretation by international, universal and regional monitoring bodies for migrants' rights and states' obligations in time of crisis, notwithstanding this process, we still require a great dose of persistence and determination to be able to effectively be the right answer to the current challenges we are faced with. Thank you.
Thank you. Thank you very much, Francesca, for digging so deeply into the issue of vulnerability. And I think your presentation opens the way very nicely to the next presentation, the last two presentations on healthcare and higher education. So I'm happy to give the floor to Stefano Angeleri from the University of Galway, the Irish Centre for Human Rights, where he's doing a PhD. Stefano will engage with the issue of healthcare. What? Yeah. With the issue of healthcare and of undocumented migrants. And he criticized the fact that this has emerged as a right to emergency treatment only, without going much beyond that. So thank you, Stefano.
Thank you very much, Maria Giulia, for your introduction, and thank you very much, distinguished colleagues, for coming along, and to the organizer of this conference for having me here today. So my name is Stefano. I'm a PhD student, as Maria Giulia said, at the Irish Centre for Human Rights in Galway, and my research deals with the right to health and undocumented migrants in the international human rights context. So today I'm here to talk about the health care of undocumented migrants, so a part of the right to health, of the scope of the right to health. I changed actually the title of this presentation because the previous one was a bit pessimistic. So I'm looking at the state of the art in European human rights law and in international human rights law. So these are my research questions that guided me in drafting this paper. So what do European and international law tell us about the conceptualization of the right to health for undocumented migrants? And while answering this question, considering the topic of this conference, which revolves around emergency, there in my mind there was the question of, are these legal frameworks, European human rights law and international human rights law, generally universal, or are they following an emergency-only approach to health? And first of all, to answer this question, we need to address what are the limits and also the potential of these two legal frameworks. So this is my outline. I mean, preliminary remarks actually are, sorry, that's not very professional. But, I mean, we mentioned during these 2 days part of my preliminary remarks, so I will go quickly on them. Then I will analyze the European human rights framework, perhaps focusing a bit more on the ICHR and the European Social Charter. And then I will move to the right to health in international human rights law. And then I have some few conclusions and perhaps an utopian wish list. So preliminary remarks. What I call, I mean, the clash between sovereignty and human rights law and the historical neglect of economic, social, and cultural rights vis-à-vis civil and political rights are those that I call the root causes of the restriction of rights in this area. So we all know, we touched this topic earlier yesterday. So state sovereignty as an exercise of imperium over people living in a territory, the right of states, according to international law, public international law, to enact, enforce, and adjudicate laws. And a maxim of international law, of international human rights law itself, is that the state has the right to control the entry, residence, and removal of aliens. And on the other side, so a power, and on the other side we have a limitation of power, and this limitation of powers derives from asylum law, refugee law, and in my area of expertise and research, human rights law, treaties, and obligation. So very quickly on the neglect of economic, social, and cultural rights versus civil and political rights, let's start by saying that our European context of human rights is dominated by an attention to civil and political rights. Let's just look at the European Convention of Human Rights. Even if it has interpreted in a way to extend its scope to socio-economic deprivation, still it remains an instrument dealing principally with civil and political rights. And the European Social Charter, which is the sister of the European Convention of Human Rights in the Council of Europe legal framework, is actually undergoing a process to make it more, the Turing process, to make it of a more visible instrument. Okay, so this conference revolves around emergency. So I don't agree, like many of you, on the idea of describing immigration as an emergency of these last years. And I'm focusing on this word, emergency, in relation to the access to healthcare. So what is emergency healthcare and what is primary healthcare, which is actually important to understand what are the different standards, respectively, in the European system of human rights and in the international human rights system. So I will start from the latter. And according to the Declaration of Alma Ata in 1979, primary healthcare is, very briefly, so there is a long declaration, but it addresses the main health problem in a community, providing promotive, preventive, curative, and palliative care, and include at least the treatment of the most common disease. On the other side, we have an emergency healthcare approach, which focuses explicitly just on the critical problem for health of individuals. So in another way, caring just for the life, the preservation of the life. So that is the underpinning interest behind an emergency care approach to health. It's not the highest attainable standard of health as set forth by international instruments. Okay, so now after this very brief preliminary remarks, I'm approaching the right to health care in Europe. So let's start by the European Convention of Human Rights. So we have in Europe a problem of limitation of competence, actually, because the European Convention of Human Rights, even if from Erie versus Ireland, it expands its scope, also material scope, also to the area of socioeconomic rights. When it deals with socioeconomic rights, the case law of the court actually is pretty much settled on the very high margin appreciation of states. Because in the area of socioeconomic rights, at stake we have money, resources. And so the court has a sort of restrictive approach, conservative approach. And in the area of healthcare, so what are the main articles, the main provisions that are employed? There are Article 2, Article 3, Article 8, Article 14 of the ACHR, and I will focus my attention on Article 2 and Article 3. Article 2 and Article 3 are, as everybody knows, the right to life and the right not to be subjected to torture or ill treatment, and their threshold of applicability is very high. So in my area, the area of healthcare, you need a really qualified deprivation of socioeconomic rights, of healthcare, denial of healthcare, in order to trigger the applicability of these rights. I make an example that has nothing to do with migration. Campenau versus Romania. It's a Grand Chamber judgment, 2014, and in that case, the court held a violation of Article 2 of the positive obligation under Article 2, but we had a situation in which this Roma child in Romania, abandoned at birth, suffering from, that was HIV positive, suffering from disabilities. So in that case, his vulnerability was taken into account, but you will understand that it's a very highly qualified case of vulnerability. And Article 3, once again, we have a really high threshold of ill treatment. So from Kudla versus Poland, in this area, but also in other areas of scrutiny of the court, we know that the assessment of ill treatment to trigger the applicability of the Article 3 must entail a certain level of severity. And the level of severity is relative. The assessment is relative and considered in the circumstances of the concrete case. And once again, it's pretty high the threshold to reach it. So in a way, I would like to conclude on European Convention of Human Rights, mentioning two cases, MSS versus Belgium. It was mentioned before during this conference. And we had a situation of an asylum seeker, as Francesca mentioned before. Asylum seeker in that judgment were considered as a group vulnerable. We had a situation in that case of extreme poverty, socioeconomic deprivation, while conversely, in cases concerning irregular migrants, which is the group on which my research is focused on, irregular migrants has never been considered vulnerable per se by the court. We need additional level of vulnerability, an health condition, a personal state, being a child, belonging to a minority group. European Social Charter. So European Social Charter is actually the instrument that we should rely on dealing with the right to health. But we have a great problem with the European Social Charter, among others. That is the European Social Charter has limits its personal scope, so its application ratione persone, to citizen and regular people with a regular status in the EU, which qualifies the European Social Charter as a peculiar human rights instrument. Regardless of this, the European Committee of Social Rights, which is the monitoring body of the Social Charter, with a very creative jurisprudence, extended the scope of the Charter also to people without a regular status. But with a teleological interpretation, considering the complementary nature of the ACHR and the European Social Charter, and also elaborating its jurisprudence, taking into consideration other applicable rules in these particular areas, or the UN human rights instruments, for example. The extension of healthcare for undocumented migrants was just for adult irregular migrants only at the level of emergency care. I will skip on the European Union because I'm afraid that I don't have time. But even there, in the area of human rights, health, and immigration, we have a lot of limits of competence. International human rights law. So we have just seen the picture from European human rights law is not very encouraging. It's actually very control-based and emergency-oriented. In international human rights law, Article 12 of the ICSCR, International Covenant on Economic, Social and Cultural Rights, grapples with the right to healthcare and define the right to healthcare as the right of everyone to the highest attainable standard of physical and mental health. So we all know that the ICSCR actually is an instrument. General obligations according to this instrument are of progressive realization. So basically states are required to take steps today to aim at the full realization of the rights in the future. But in order to prevent states from delaying their realization of these rights in the future, in a well-known moment in the future, the Committee on Economic, Social and Cultural Rights, which is the monitoring body of the ICSCR, endorsed the concept of minimum core obligations from the 90s. And the minimum core obligation are a very debated concept in the doctrine, in the scholarship, and not very settled. But the idea behind it was that at least essential level of the rights set forth in the ICSCR should be realized immediately. And in relation to healthcare, we have a series of them set forth in the General Comment 14. And the first, which I focus on, is the obligation to ensure the right of access to health facilities, goods, service conditions on a non-discriminatory basis, especially for vulnerable or marginalized groups. So, are undocumented migrants a vulnerable group according to the international human rights system? Yes. In February this year, as an informal follow-up of the New York Declaration in September last year, the Committee on Economic, Social and Cultural Rights issued a statement titled Duties of States Toward Refugees and Migrants under the ICSCR. And this document, this 4-page document, focused on immediate obligation, focused on prohibition of discrimination, also on the ground of migration status, so also on, for people with irregular status, and core obligations, and finally, Section 3 is titled Integration of Refugees and Migrants and the Specific Vulnerability of Migrants. In international law, we have also different messages also coming. For example, the Convention on Migrant Workers, these very little ratified instruments in the 1990s, actually constitutionalized, I would say, a different treatment for regular and irregular migrants. And when the right to health is concerned, actually irregular migrants are entitled only to emergency treatment. But in the area of, in the area of post-2015 social development, sustainable development goals, we have a bit of, to a certain extent, a synergy with the concept of minimum core obligation, with the concept that I mentioned at the beginning of primary health care for all, because target 3.8 of the Sustainable Development Goals actually is universal health coverage. And this universal health coverage is framed in a similar way to the minimum core obligation in relation to health, because actually it is focused on the promotive, preventive, curative and rehabilitative basic health care for on a universal level, I mean, personally speaking, I mean, from a personal perspective, scope, and with a focus on poor, vulnerable, and marginalized sector of the population, not of citizens. Okay, I am wrapping up on this. So European and international human rights law, I mean, arguments, also, I mean, sources are very different in this regard. European human rights law, grappling with limited competence, razione persona and razione materie, tend to be more emergency-oriented rather than protection-oriented. While international human rights law is more protection-oriented, but I mean, this is my perspective. I mean, before being a PhD student, I was a lawyer, so I really care about a positive perspective. So most of the decisions coming from the monitoring body of the UN are not binding in nature. So how to go beyond this emergency approach to health and bridge the gap of protection? So this is my wish list, titled Harmonized Dialogue Between Human Rights Adjudicators. And first of all, it's very desirable that the UN Committee on Economic, Social and Cultural Rights clarified the concept of minimum core obligation. It did something in this document, so it's a good progress. But perhaps using the newly established individual complaint mechanism that put the committee on a sort of parallel line with other international or European individual human rights adjudicators, and to make of the European Social Charter a really universal instrument. 1 minute, 2 minutes.
No, fine.
So, I mean, there is no discussion to extend the appendix of the European Social Charter to irregular migrants. No mention in the Turin process. So at least the European Social Committee, because it was very brave and in its interpretation, perhaps it might employ a clarified concept of minimum core obligation with an emphasis on non-discrimination and vulnerability. And finally, by way of a contextual interpretation of standards, real European courts of law might decide to incorporate these arguments and going beyond a mere emergency approach to health and provide, with the words of the Committee on Economic, Social and Cultural Rights, General Comment 3 and 14, at least essential level of primary health care. Thank you very much.
Thank you. Thank you very much, Stefan, for your presentation and your final wish list. Hope adjudicators will follow your advice. We now move to Heidi Gilchrist, assistant professor at Brooklyn Law School. Heidi will actually touch upon a very interesting and original issue. She deals with not with the right to education, but with the right to higher education. And she will ask what role the right to higher education might play in the current refugee crisis, but also in countering and contrasting terrorism.
Thank you very much. You summed them up very, very well for me. I understand that I'm last and I'm between you and lunch, so I will try to get through this as quickly as possible. I'm very excited and honored to be here. I'm an assistant professor of legal writing at Brooklyn Law School and a lecturer in law at Columbia Law School in New York City. And since she already said what I was speaking about, I'm going to jump right in. I'm looking at what is this human right to higher education and the possible impacts on refugees and terrorism. And so I'm starting with the Universal Declaration of Human Rights. And 1948, it stated very clearly everyone has the right to education. And then it does specifically mention higher education shall be equally accessible to all on the basis of merit. And it talks about the purpose of this. It's directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. It shall promote understanding, tolerance, and friendship among all nations, racial or religious groups, and shall further the activities of the United Nations for the maintenance of peace. And so this is the real purpose of this right. And the International Covenant on Economic, Social, and Cultural Rights, which is widely recognized in 1966, also states generally everyone has the right to education. And then specifically, higher education shall be made equally accessible to all. So it's really about access on the basis of capacity. And notice the word changed from merit to capacity, which I think is a good change, and I'll speak on that in a second, by every appropriate means, and in particular by the progressive introduction of free education. So obviously it's an aspirational right. It's not saying that it's not saying every single person has a right to higher education. There's definitely and there needs to be capacity. And then the scope of this right is what I'm really interested in working through right now. And if this is along the lines of anyone else's interest, definitely I would love to talk further. And so the Convention on the Rights of the Child also has higher education accessible to all on the basis of capacity by every appropriate means. So the right to higher education is in many of the international human rights treaties. It's also mentioned in the Treaty on the Discrimination Against Women and racial discrimination, and about equality of access to higher education. Specifically from the Refugee Convention relating to the status of refugees, then it's a little less clear. They say the contracting states shall accord to refugees treatment as favorable as possible, and in any event not less favorable than those accorded to aliens generally in the same circumstances. And then the European Convention for the Protection of Human Rights and Fundamental Freedoms also has no person shall be denied the right to education. And that has been, in the case Douglas v. North Tyneside, has been recognized to be include higher education as well. The court stated there's no linguistic reason for restricting education to exclude higher education, and that there's just no reason to stop at any certain point. If you want to be a doctor, you can't stop at elementary education. Okay, so hopefully I've convinced you that there is a right to higher education, and now we can start to discuss basically what the scope of this right is. And I look at a case from the UK, Hurley v. Moore, Secretary of State for Business. And so basically in 2010, the UK passed the higher education regulations, which included, they changed the maximum tuition that could be charged from £3,375 to £9,000. So obviously that was a very large increase. And so two students argued that the increase was a breach of their right to education conferred by Article 2 of Protocol 1 of the European Convention on Human Rights. The court found that the tuition fee increases alone did not infringe upon the right to education, and their reasoning was that there was that they had looked at how it would affect students of disadvantaged backgrounds, and there was wide availability of loans, and that they sort of touched on the fact that perhaps £9,000 was not prohibitively high, which I find, coming from the U.S., a very interesting question. I looked up before this presentation, and for NYU, for New York universities, they estimate the costs to be $77,000 a year. And so to me, that sounds, and there are, in the U.S., there are loans, and there's public institutions, but once again, I'm looking at this very interesting idea of the scope of this right. Okay, sorry. So I want to talk a little bit about the United States, since obviously that's where I come from. And so actually in the United States, unfortunately, education is not considered, public education is not considered a fundamental right under the Constitution. And it's in many state constitutions, but it is not recognized by the Supreme Court. That's not to say that the Supreme Court hasn't recognized that education is important, and so I have a quote from Brown v. Board of Education, which you maybe heard of, and I'll just, the last sentence. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. And so in the United States, it's more about equality, not discriminating against certain groups. And although, interestingly, in 1982, the Supreme Court in Plyler v. Doe found that states cannot constitutionally deny undocumented students a free public education. So undocumented aliens in the United States actually have a right to education. However, since my focus is higher education, it goes state by state, because that's our system in the United States. Some states have been more inclusive undocumented students, enacting laws which allow undocumented students to establish residency and acquire tuition assistance through non-state funded scholarships, but other states have made it basically impossible for undocumented immigrants. So these are the questions I'm looking at. Does the right to education, and I know in Europe it varies from country to country, does it need to be, in the treaty it says progressively, with free education as being the goal. Is that indeed the goal? Would wide availability, the way the UK case came up with, would that be enough, even though there are studies showing that those from disadvantaged backgrounds don't take out loans because it's so worrisome if you have very little to begin with, and then actually how far does this go? Because at college or university enough, or does it go beyond that? And I have a quote from another Supreme Court case talking about in the United States how important even beyond colleges. In the United States, individuals with law degrees occupy roughly half the state governorships, more than half the seats in the United States Senate, and more than a third of the seats in the United States House of Representatives. So it's not even just college if you want to really participate in the democracy. All right, sorry, I know I talked very fast. So, everyone here, I hesitate with this because it seems awfully a lot like this huge luxury. And so I want to quote the Council and the Committee on the Education and Social Rights discussing why it isn't such a lofty goal after all. Education is both a human right in itself and an indispensable means of realizing other human rights. As an empowerment right, education is the primary vehicle by which economically and socially marginalized adults and children can lift themselves out of poverty and obtain the means to participate fully in their communities. But the importance of education is not just practical. A well-educated, enlightened, and active mind, able to wander freely and widely, is one of the joys and rewards of human existence. So where does this fit in with the refugees, and so that's where I have a UNHCR report that says that of all the refugees, only 1% is enrolled in tertiary education, and in terms of the Syrian context, many of the refugees were university students and professors. And now only 1% is in higher education. And so I'm not obviously arguing that this is a solution to the refugee crisis. I know there's basic needs needing to be met. But I'm talking about, for this very small number, but something that should be above 1%, that this is of critical importance. In the Syrian context, there's a real danger of a lost generation. If the UNHCR, they estimate most displaced people are displaced for 20 years. So therefore, these students that should be getting their engineering degrees and medical degrees are now not going to have it. And we need people to be able to go back to their home countries to rebuild the countries when the conflict does indeed end. And for the people that stay in their host countries, invaluable perspective as immigrants. And so I want to, on a positive note, look at the opportunities. Higher education institutions are uniquely positioned to help. They may have less red tape. There's massive, I forget what MOOCs stand for, massive online, it's, they can beam classes into camps, and that can help maybe with language facilitation because there's obviously problems of language. And higher education really helps from a social inclusion perspective, having people in the classroom discussing like if we're talking about refugees, having people from these different countries with their perspectives can really make a difference. And once again, I'm not talking about the masses. I'm talking about just you have to find the right number. And then terrorism. From a counterterrorism perspective, I'm not really speaking of the few people that you might prevent from becoming a terrorist, because I don't necessarily think that would be such a large number, but yes, there's that aspect. But I'm also talking about, to combat terrorism, we need to better understand the problems and the people who have, maybe a family member swayed by ISIS. I would think their perspective on how to combat it could be extremely critical in the current situation. And as well as we don't want failed states. So we want people to go back to Syria and rebuild it so it doesn't become, it doesn't remain another breeding ground for terrorism. And then, of course, I have to admit the many challenges. And obviously, scholarships and expenses. A scholarship tuition may not even be enough. Obviously, there's living expenses. The lack of documentation and credentials. People usually leaving war-torn countries don't take their university diploma with them. And so there's workarounds, but they take time and effort. And information access. On another positive note, though, we usually hear about social media being used as a terrorism recruitment tool. Here is when it's actually being used to connect scholars to the opportunities that are available. There's international organizations in the European Union that have scholarships already in place, and they're really seeing that on Facebook as how they're connecting scholars to these opportunities that are available. Also here I want to say that I don't think of this as being a European problem. I think we in the U.S. should definitely play our role in this, and we have many universities, and some are already taking students, and we should continue and increase those numbers, although right now may be difficult. Okay, and the last two problems are language of instruction. Like the university in Syria, the language of instruction was Arabic. So even if they go to Lebanon, the language is French, and obviously if they go into Europe, so there is a language issue. And then discrimination, obviously, with terror attacks, people are worried, and and there's just discrimination. However, I want to once again be positive, so I'm going to say it's too important to ignore. And I have two quotes, one from Arno Penzias, the Nobel Prize winner who helped develop the Big Bang Theory. And he said, "Education turned me from a poor refugee kid into a quite prosperous and well-supported scientist and a member of the upper middle class." And then I have Nelson Mandela, "Education is the most powerful weapon which you can use to change the world." And it worries me because if it's not education, then it's just weapons, which isn't so good. And then finally, I just ended with a slide from my, after Trump's travel ban, these signs popped up around my children's school and it made me happy. So I figured I'd end with that. All right.
Thank you very much, Isaac, and thank you for bringing us into the issue of education, which is so crucial, and is crucial has an impact in addressing current crises, but also in preventing future ones. So, and also for your perspective on the United States, so to share it's a common problem, it's a common issue, it's something we have both in Europe and the United States. So thank you very much for that. I think now we can open the floor for discussion, and so collect a few questions from audience, if any. You can raise your hand. Yes, 1, 2, 3, 4. Okay, fine, 5. Thank you. Let me remind you. Okay, yeah, thank you.
Thank you very much for all the interesting observations which came by this morning. I have a question for Heidi Gilchrist. I'm afraid the answer is no, but I'm going to answer it anyway. I'm going to ask it anyway. And the question is, in your research through the status and content of a human right to higher education in the United States, did you ever come across some reference to international instruments or not? Did you ever come across to any reference, the Supreme Court, agencies, whatever, made to some international instruments?
No. Oh, no, there are actually other...
Heidi, we collect some questions and then we answer all together. Fine, thank you. Elspeth, yes, please.
Yes, thank you very much to all of the speakers for some really interesting perspectives on a number of fields that I don't know that much about. So I really learned a lot. For the first three speakers, I want to pose more or less the same question, which is the first three of you, and that is that to what extent can one actually get to grips with your subject if you don't disaggregate the state? And I think to some extent with Ralph, I would say, are you not looking at a struggle that's interior to the state that may be played out extraterritorially between the Home Office, the Foreign Office, and a number of other ministries, where there is an increasingly imperial vocation of the Home Office to get every other ministry in the whole of the UK to do their job for them. So, can you understand the struggles if you don't disaggregate? And to Francesca, it's sort of the same question. Because one of the things that I find fascinating about how suddenly vulnerability has risen up to, it's like exploded out there into our legal realm, is can we understand this outside of a disaggregation of states between interior ministries and the medical professions about who's entitled to decide whether somebody is vulnerable? And I'm not sure it's just the medical professions. I wonder if it's the social ministries. So is this about a struggle where interior ministries are seeking to expropriate from other ministries the capacity to determine whether foreigners, at least, are vulnerable or not? And it's just a question I'm putting forward. And I'll put the same one to you, Stefano, that one of the things that we've seen an awful lot of is the power of the medical professions to resist domination by interior ministries, and the capacity as a field with a tremendous amount of power within the state to say to interior ministries, piss off. Public health requires that everyone who's on the territory receives health treatment. And I wonder whether some of the way in which this has become legalized and perhaps displaced into international venues is part of that very powerful confrérie of the medical professions, which, they may have a pretty weak international institution in the WHO, but nonetheless they have a very pivotal role in their societies, and I wonder whether that's part of it. And then my final comment is about the education thing. One of the things that I heard that I haven't followed up that you might be interested in is that in 2015, and I was a bit surprised about this because I assumed it was a Länder competence, not a German federal government competence, but apparently all Syrians, and I think they included the Iraqis, and I think they included the Afghans, who arrived who had been university students, were permitted immediately to go into university if they were in one of 5 fields. And all I can remember is engineering. I can't remember what the other 4 are. But I remember there was somebody complaining bitterly that they had been at the University of Aleppo studying German literature, and they weren't allowed to until they got their status, whereas the engineers, blah, blah, blah. So I don't know what happened with all of that, but it might be interesting for your discussion.
Thank you. Thank you for these presentations that were very enriching. I have a very quick question for both Stefano and Heidi. That is actually, I wanted to know what's your position regarding the limits of international law when tackling such sensitive political issues such as health care and education. Because of course, I agree, we all agree that it would be a great world if everyone could have access to higher education and health. However, at the same time, from my view, of course, we're talking about refugees, so still it is a very marginal number, and maybe the impact on national budget would not be that high. But in any case, it's something that is very related on how our national politics chosen democratically by the population and what is the political view of the state at that time. And we could see the differences also between Heidi's presentation in the United States. We have a very different view on education than what we have in Europe, for example.
It's on top. He was on top. Yeah, it's the last.
Okay, thank you very much for all your presentation. My question is to Professor Francesca Ippolito, and about the role of vulnerability, especially in the establishment of a new threshold level to declare the violation or the non-violation of Article 3 of the European Convention. And my reference is to the recent judgment of the Grand Chamber Claifia, where, from my point of view, it seems that the court has utilized this concept on a reversed way, starting from the facts that the three Tunisians applicants were not asylum seekers, so there was no possibility to conceptualize them as vulnerable groups. The threshold of in this case was lowered, so there was a declaration of no violation of Article 3 of the Convention, which turns to be, from my point of view, a pitfall, one of the possible pitfalls of the concept of vulnerability, because it seems, from my point of view, that this is a discrimination. If you're a irregular migrant, you can be mistreated, but if you're an asylum seeker, there is a violation. So there is, of course, a lower standard of protection for irregular migrants, as you have underlined it. But this is maybe one of the pitfalls of the concept, and how do you see that these pitfalls can be resolved? Thank you.
Hello, thank you very much for your presentation. Just one quick question for Heidi. Well, do you really think that states have an international obligation to give higher education to refugees, and that this obligation should be free, or is it just your wish? Thank you very much.
Okay, the last one, please. Thank you.
Yeah, thanks also from my side to the presenters for their very insightful presentations. I have a question for Francesca. From what I understand, from what I could gather from your presentation, many human rights treaty bodies have dealt with the issue of vulnerability. But it seems to me that there is not one legal definition of vulnerability. So you can be vulnerable because you belong to a certain sex, or because you have a physical disability, or because you're sick, or because you find yourself in a specific predicament, because you're in an armed conflict situation or the victim of a disaster. So I was wondering whether you've came across any attempt by a treaty monitoring body or a UN special procedure, or whether, or maybe you've done an attempt to identify the legal parameters on the basis of which one could, let's say, define the concept of vulnerability from a legal point of view. Thank you.
Okay. We can start with IIT and then going in this order. Yeah, you can choose whatever you want. Yeah, it's up to you. Yeah.
As Mary Ellen mentioned yesterday, the courts, if they mention an international treaty, and I can find you a quote I'm thinking of, but it's not as a binding obligation. It's more as if it's proving the point that they would like to make. And so I can find you some if you want. And then in terms of higher education and the state obligation, right, I actually, as I'm working through, in the U.S., which is very different from Europe, we have a lot of private institutions. So I'm also seeing the role they can play. I'm not seeing it as a state obligation. Harvard has a $38 billion endowment, and so it would seem to me that they could, play a role in educating some refugees. But yes, I think to say that once again, I'm not trying to say every refugee has a right to higher education. It's a very small number, and it's trying to use the human rights framework to find these opportunities, but not necessarily a state obligation. And then I think I was asked another question. And I think maybe your question was related to hers, actually, a bit. Once again, the U.S., they since they're not a party to most treaties, they're not using it as an obligation, but they'll use it as as a text to use when if it helps prove a point.
Okay, I'm answering for first aspect question about disaggregating states looking at these themes. Yes, it's fundamental, and as you said, regardless of the very restrictive policies and laws of states, doctors actually mobilitate themselves. I'm just thinking at Spain. Spain was a very universally accessible system of healthcare before 2012, before a royal decree was enacted, and now it's at the level of emergency care. But regardless of that, doctors lobbied, and the autonomies of regions of Spain actually extended de facto a broader right to healthcare for undocumented people. And yes, I haven't mentioned any case coming from national domestic experiences, but in part they are indirectly considered in the analysis of the minimum standards, or the minimum core obligation and arguments of the Committee on Economic, Social and Cultural Rights, because this statement that I mentioned actually summarizes legal or argumentative points made by the committee in the context of concluding observation of state reporting mechanism. So, and minimum, a level of healthcare which goes beyond emergency healthcare is what emerges from, not from the practice actually, but from what the committee requires to states in order to be compliant with the international law. And concerning your question, and the limits of international law, international human rights law is actually, international law is a law, it works on the principle of subsidiarity. It is a law made by state, for states, implemented by states, interpreted by sometimes by independent bodies. And minimum core obligation, that is my main argument, actually, they do not represent, in a way, they deals with the limits of the legal framework itself at international level, because it doesn't mean to extend completely healthcare to everyone, but at least minimum essential level, which it doesn't mean minimal. It's not emergency, it's minimum. So if you look, for example, at the minimum core obligation that's set forth by these monitoring bodies, there are a series of, they are very procedural, so they revolve most of them around the principle of non-discrimination. But yes, it doesn't mean immediately extending everything. Then when we talk about goals at more UN General Assembly, yes, there is a universal health coverage, but it's a goal. It's a point of achievement in the future. I hope I...
Thank you very much, Professor Guild. Your question about disaggregating the state, I suppose it depends what you want to focus on or look into, right? So my interest is on the general question of backlash to human rights protection and the potential unintended consequences of that, the downside consequences. And so the question would be, when is it helpful to focus on migration-related backlash as opposed to human rights backlash generally? And so, of course, if one is focusing exclusively on migration issues, then you might want to look at the particular role of the Home Office in the UK as distinct from the UK state more generally, although, of course, when you have someone who then becomes Prime Minister, who takes her views forged in that particular context and seeks to impose them generally, and of course it's Theresa May's general position to withdraw from the European Convention, then I'm not sure what the disaggregation has really helped you on that question of the backlash, because it may have its origins in something in a particular department, but is then potentially a government-wide, statewide policy. My interest anyway, though, being on backlash generally, is also on the extraterritorial application of human rights generally. And so that, of course, covers the extraterritorial non-refoulement obligation. But in other areas, there is also a backlash, also in the UK. So if we think about the main issues in the UK that have precipitated this backlash against human rights: prisoner voting, non-refoulement, and cases against relating to abuses by soldiers, UK soldiers, particularly in Iraq. And of course, they're all in a way related because they concern the rights of non-citizens. And so I think it's helpful to think about those issues collectively. And there we do see it not just being about the Home Office. So that the UK position on the extraterritorial application of the European Convention had to be defended diplomatically and publicly by the Foreign Secretary and by the Foreign Office, but was actually being driven by the Ministry of Defence because they had to respond to the cases that were brought in relation to abuses by soldiers. So there, indeed, it's helpful, actually, to not take things at surface and actually appreciate where a particular position is being driven from, which was indeed not the Foreign Office who had to articulate it, but rather the Ministry of Defence. At the same time, I suppose I would kind of throw the question back to you. What, though, can we do with that insight, right? So for my analysis, I'm not sure what difference it makes if it ends up being adopted as the state's position generally, and that ends up precipitating a backlash which also operates generally. Then why does it matter for my consideration about unintended consequences that it may have had its origins in one particular department? So maybe we could talk about it afterwards, whether there's something in that that's helpful on that issue, even though it may clearly be helpful in other ways in terms of explaining the dynamics that are going on that precipitate these positions.
May I join to this point 1 second and abuse my role as a chair? Just an input, but rather than considering only the extraterritorial application of human rights as the pathology here, wouldn't it be possible to bring into the picture also other drivers that might also lead to restrictive measures by states and so have unintended consequences? For example, simply and also more banally, for example, electoral interests or xenophobic reasons, or simply the unwillingness of states to feel bound by international legal regimes?
Well, so to take the in reverse order, so the unwillingness of states to feel bound, I mean, indeed, the backlash can be understood partly by a decision maker subject to a constraint who wants to be free of that constraint. What's interesting to me is that in the context of there's something about these related topics, migrants, foreigners generally, so extraterritorial victims of human rights abuses and individuals who be potentially subject to refoulement, that when they are subject to a legal protection in human rights law, has precipitated a backlash of an order that is of a different character from the usual, so for example in the UK, the usual resistance, criticism, but ultimately staying within the regime. And my hypothesis is that it's not accidental that it is these issues which have, there's something about them which has precipitated this qualitatively different response, and it's a response of a severity that places an existential challenge to the very continuance of human rights law. And of course what links them is that they are all about non-nationals or foreigners. And so indeed, to go to your first point, ultimately one can see this as a challenge rooted in xenophobia and racism. And it's decision makers responding to sentiments of that kind that lead to these positions. And so one question then is, if one is seeking to address these responses, one has to look at the root cause, and that cause, and be realistic about the extent to which that cause can be, that the cause being racism and xenophobia, in the popular imagination, can be anything other than challenged at the margins through legal mechanisms, and how fragile that is if that is all we are relying on. And of course, the whole idea of human rights law, which is its great innovation, the great innovation of the 20th century, is to protect individuals regardless of their nationality, and therefore including people who are foreign and cannot rely on the popular view to protect their rights. So it's a tension here in what is inherent in the notion of human rights law, but then the problem of that coming up against popular sentiment that is directly opposed to it, and these topics are absolutely at the center of that tension.
Yeah, no, thank you. It would be interesting to see what might be the practical implication of a scenario, a typical scenario in which migrants are at sea, rescued at sea, and still need access to international protection, and therefore also, like there we face a situation in which non-refoulement should be applied also in extraterritorial contexts. But there is no time to discuss it here, so we will do it later over drinks. Last word, Francesca.
Yes, I try to be quick. So I think I could start with Emanuele and then come back to Professor Gill, so maybe we can have a fil rouge. So for a legal definition, I said that vulnerability is quite chameleontic and kaleidoscopic notion. And so depending on which is your perspective looking at, and so it's also replying for the Claifa case, the monitoring body looking and use the concept very differently. So for the access to the territory, the interpretation is very strict, and so the notion also is very narrow-minded. And wise in the context of deprivation of liberty, so administrative detention, the way of looking at the notion is different. But for giving some common point, I think that dependence is one of legal element of the notion. Dependence on financial dependence or emotional dependence from private, so from the family or from the states, for the fulfillment of rights. And then the notion of autonomy that plays a role also for procedural rights, so the access to procedural rights. And we have also the notion of special needs that is not very clear as well, but we can find some elements in normative instruments, for instance, in the EU legal order. And so these are quite the legal element of the notion that I was able to find that are common in horizontal looking of binding monitoring bodies or universal monitoring bodies. And but for the question of Claifa, I think that it depends of the fact that the court was looking at irregular migrants. It was not really relevant if they have made the application, it was rejected or not. But they are irregular migrants, and the court is very close when looking at the expulsions and the access to the territory in using this notion to open, the jurisprudence in other way. Whilst it has starting to do for the labor exploitation, so Article 4, as regarding to irregular migrants, and we can see how it can progressive and maybe further influence also the other situations. And for the disaggregation of states, there is a risk that the Interior Ministry is the one that could be the relevant one in deciding, who is and determining who is the vulnerable. But I think that we have a quite optimistic message from the European Court of Human Rights, though in only the selective area by now of the administrative detention, because the court spoke about who claim to be vulnerable. So it's not maybe need to be assessed, but the standard of proof is lowered in this context. And so this could be overwhelm the problems that Professor Gide envisaged. And also for children are the most broad category for which the vulnerability notion have been applied. There is a sort of presumption de jure that they are vulnerable. So there is a problem on how can be assessed the age of the child, and this is a big problem. But there is still this presumption that is a favorable element. So.
Thank you very much. Thank you, the speakers, for this very intense panel, for your question. So please join me in thanking the speakers with a round of applause. Okay, we are off lunch.